Greetings and a very warm welcome to everybody tuning in around the world. This is International Law Weekend 2020, and this session is titled Obligations Erga Omnes Before the International Court of Justice. My name is Nawi Ukabiala. I'm a senior associate in the New York office of Debevoise and Plimpton. My practice focuses on international arbitration and public international law. I'll be your moderator today. I'd like to thank Abila for having me moderate this panel, and to all the viewers tuning in, and to each of the panelists. Now, I'm joined by an exceedingly distinguished panel, and I really must say it's an immense privilege, not only for me, but for everybody attending this session to be able to benefit from the perspectives of such an esteemed group on such an important issue. For the type of people that attend a panel on Erga Omnes obligations and the ICJ, our panelists really require no introduction. Nevertheless, I'm expected to introduce them, but I'll be brief in doing so because I could very easily take up the entire hour listing the accomplishments of any one of them. So it's with great pleasure I introduce first Judge Bruno Sima, who is a former judge at the ICJ. He currently sits on the Iran-US Claims Tribunal and is a professor of international law at the University of Michigan Law School. Next, I'm delighted to introduce Dr. Marja Lehto. Dr. Lehto is an ambassador and senior expert at the legal service of the Finnish Ministry for Foreign Affairs. She's also a member of the International Law Commission and Special Rapporteur on the Protection of the Environment in relation to armed conflict. Dr. Lehto is adjunct professor of international law at the University of Helsinki. And last but not least, I could not be more pleased to introduce Mr. Paul Reichler, who is a partner and co-chair of the International Litigation and Arbitration Department at Foley Hoag LLP in Washington, DC. Today's panel is very much inspired by the ICJ's Provisional Measures Order of January this year in Gambia versus Myanmar. The court held that the Gambia had prima facie standing to enforce obligations under the Genocide Convention against Myanmar based on the Erga Omnes partes nature of those obligations, even though Myanmar had no special legal interest in the legal controversy. It represents a profound development in the court's Erga Omnes jurisprudence because although commentators have long suspected that this was possible in theory, it's the first time that the court has ever found that an applicant has standing based solely on the Erga Omnes character of the obligations at issue. It raises a host of intriguing issues and possibilities, which we'll cover today. The concept of Erga Omnes obligations, it's captivated the international law community ever since the ICJ first introduced it in the famous bit of dictum in the 1962 judgment in Barcelona traction. How we'll proceed today is Judge Sima will discuss how since then, the development of the Erga Omnes principle in ICJ jurisprudence and in international law generally has been one of the most important features in the evolution from bilateralism to shared community values in international law. He'll also explain the important difference between obligations Erga Omnes and Erga Omnes partes, and discuss the autocatalytic relationship, the symbiotic relationship between the ICJ and the ILC and the progressive development of this area of the law. Then Ambassador Lehto will take the baton and discuss the role of the ILC in greater detail. She'll touch on the emergence of Article 48 of the ILC articles on state responsibility and the controversies that emerged in the state comments to that article over inconsistent state claims and collective countermeasures. She'll also look at examples of selfless interventions to enforce community values and discuss some of the challenges and opportunities for such interventions. And then finally, Mr. Reichler will discuss the development of the Gambia case, the significance of the court's order, and the conservative instincts that it prevails over, as well as its implications for intervention under Articles 62 and 63 of the ICJ statute. And then we'll all have a more forward-looking discussion in which we'll explore some of the implications of the court's decision. That's a lot to cover, but we'll try to leave 10 minutes at the end for audience questions. As questions occur to you, we would be grateful if you would just convey them using the Q&A function in your screen, and I will then convey them to the panelists during the Q&A session. So without further ado, I turn it over to Judge Sima to trace the evolution of the Erga Omnes principle and the progression towards shared values in international law.
Thank you very much, Nawi. Should we try to get the ambassador into the picture too? I don't see her. I see Paul Reichler and yourself, but maybe she should turn her video on again. All right, just as an organizational matter. Now, what you're going to hear is a story of progress in international law. It is the story of an important chapter depicting international law, overcoming its traditional feature and its traditional weakness, bilateralism. What bilateralism means in our context is that when obligations under international law are breached, to respond to the breach, to claim, and if possible, to enforce performance is exclusively up to the state or other entity that has been injured. It is simply nobody else's business. It is easy to see that such a structure will not be able to cope with the emergence of community interest in the performance of certain obligations recognized as fundamental. The growth of such community interest has made many observers call for a cautious but thorough accommodation of these interests also in the general law. There was, however, and still is, strong opposition in the way of this development. The bilateralism I have just described is still to be found in many features of contemporary international law, and it is still regarded as a factor of safety and reliability by conservative members of our profession. To mention just one name, Prosper Weil, in his famous article published also in the American Journal. Well, be that as it may, bilateralism is the point of departure of our story. This story is made up of 4 chapters. The first chapter is very short. Its dramatis personae is the International Court of Justice. The year is 1970, and the chapter has a title, Barcelona Traction. What the court says there, en passant, is a shot before the bow of bilateralism, and it is fired without warning in the midst of an argument dealing with a typically bilateralist topic, namely diplomatic protection. The court suddenly changes the subject and points at what he calls an essential distinction that should be drawn, and I quote, between the obligations of a state towards the international community as a whole and those arising vis-à-vis another state in the field of diplomatic protection. By their very nature, the former are the concern of all states. In view of the importance of the rights involved, all states can be held to have a legal interest in their protection. They are obligations erga omnes. Such obligations derive, for example, in contemporary international law from the outlawing of acts of aggression and of genocide, as also from the principles and rules concerning the basic rights of the human person, including protection from slavery and racial discrimination. Now, these words are no more than obiter dicta, but they set in motion a lawmaking process of the greatest importance. From now on, it also involves the UN International Law Commission, and it is a process in which these two bodies interact, follow each other's steps, and pass the ball among themselves. The next chapter thus takes place in Geneva, in the International Law Commission. Actually, it has a slow start because for several decades, there hasn't been much acclaim for the Barcelona Traction idea. It looks like it might remain an exotic or quixotic outlier and a playground for academics like myself. But fortunately, this turns out to be wrong. The genie of obligations erga omnes is out of the bottle, and the International Law Commission is ready to put it to practical use in its codification project on state responsibility. Under the leadership of Special Rapporteur James Crawford, the Commission has just freed itself of the Cold War monstrosity of, quote, international crimes of states. Further, it has already paved the way for considerations of community interest. It has done so by adding a public law element to the traditional bilateralist, civilist features of traditional state responsibility, most importantly, by eliminating damage as a necessary element of injury and the internationally wrongful act. And then the Commission makes a great leap forward in our context. It grants the right to invoke the responsibility of a wrongdoer, not only to an injured state, that would be Article 48 of its articles, but also to a state other than an injured state, Article 48. This might not sound particularly elegant, but it is important enough to read it out. So it says, any state other than an injured state is entitled to invoke the responsibility of another state if A, the obligation breached is owed to a group of states, including that state, and is established for the protection of a collective interest of the group, or B, the obligation breached is owed to the international community as a whole. Second, any state entitled to invoke responsibility under paragraph 1 may claim from the responsible state A, cessation of the internationally wrongful act and assurance and guarantees of non-repetition, and B, performance of the obligation of reparation in accordance with the preceding articles in the interests of the injured state, if there is one, or of the beneficiaries of the obligation breached. What this article accomplishes is the opening of the state responsibility regime to international legal obligations pursuing community interests. In our present context, obligations erga omnes established by a group of states in the form of a multilateral treaty, that is, obligations erga omnes partes. And for reasons of time, even if it disappoints Nawi, I will in the following limit myself to this category, but of course we can take it up in the discussion. Thus far, my chapter 3. Now, what to do if a state other than an injured state might not rest content with invoking responsibility and demanding performance, but intends to, quote, induce, to use the euphemism of the International Law Commission's articles, to induce the violator to make reparation and return to compliance. This is the stuff of my chapter 4. But now it gets toxic. We find ourselves in the realm of countermeasures or reprisals, as they were traditionally called. And here the International Law Commission was made aware that the majority of states, while being in favor of providing obligations erga omnes with some additional strength, felt that the vigor of non-injured states applied to the enforcement of community interests had to be put on a leash. What happened was that in its report to the UN General Assembly on its session in 2000, the Commission had added a provision, Article 54, to the regime of invocation of responsibility, a provision which entitled other than injured states to engage in countermeasures, responding to serious breaches of obligations arising under norms of jus cogens. Of course, these countermeasures would have to be submitted to the restrictive general regime tailored by the Commission, use of force being excluded without any exception, but still, the reaction from New York was quite clear. In the words of Special Rapporteur Crawford, I quote, "A number of governments were concerned at the possibility of freezing an area of law still very much in the process of development. For others, Article 54 raised controversial issues about the balance between law enforcement and intervention. It reopened questions about the linkage between individual state action and collective measures under the United Nations Charter or regional arrangements. Thus, the thrust of government comments, both from those generally supportive of and those hostile to countermeasures, was that Article 54, and especially paragraph 2, had only a doubtful basis in international law and would be destabilizing. As a result, when the ILC met again in 2001, it eliminated the controversial affirmative provision on collective countermeasures and replaced it with a general saving clause, which allows only so-called lawful measures, that is what our textbooks call retortion, in response to breaches of Erga Omnes partes obligations. That's as far as the International Law Commission was able to contribute to our story. Now, one might take the view that the Commission ultimately deprived the progressive rules it had designed of most of its bite. But it also makes us realize that the enforcement, be it unilateral or collective, of obligations serving community interests in the absence of a sufficiently organized community can open a can of worms. Sometimes the road to hell is paved with good intentions, and this might be a good example. There is, of course, a much more desirable alternative. This is the fifth and concluding chapter of my story. The alternative is the realization of the state's individual or collective droit de regard by taking the violators to court. The only danger I can think of here would be a lack of courage on the part of courts and tribunals to deal with such cases effectively, with most of their members still educated in a bilateralist spirit. Fortunately, in our story, this is not the case. A few years after the International Law Commission had completed its work on state responsibility, the International Court of Justice took the matter over again. It had in the meantime confirmed and specified some features of obligations erga omnes in a number of cases. But in 2012, in its judgment on the case brought by Belgium against Senegal on violations by Senegal of the UN Convention Against Torture, the court had a still better opportunity, and it took it. It developed the legal regime of our obligations erga omnes much more fully, among other things, by following the, now I have to find the last page of my, well, I can tell you, by following the structure of the International Law Commission. And of course, now we are having before the court the case of the Gambia brought against Myanmar, on which Paul Reichler is going to tell us. So I think, just to conclude, that this is an interesting story. It is essentially a success story, I think. I'm fascinated by it, which of course might be due to a certain, let's say, professional story of myself, because I had the pleasure of being a member of the commission and of the court in one of these moments. That is my story. I hope you found it interesting. Thank you very much.
Thank you so much, Judge Sema, for giving us that historical context. I think now that's a perfect moment to turn to Ambassador Lehto for a discussion of the ILC articles on state responsibility and some of the controversies that emerged in the state comments, and a discussion of selfless intervention to enforce community values more broadly.
Thank you, Nawi, and good late evening from Helsinki. Thank you also to Judge Zima. It was really a pleasure to listen to your overview of how the concept of obligations erga omnes was consolidated in the interaction between the ICJ and the ILC. I was asked to situate the Gambia-Myanmar case in a broader diplomatic context. I will do so in two ways. I will first dwell a little more on the debates on what became Articles 48 and 54 of the ILC Articles on State Responsibility, and more specifically on how they were received by states 20 years ago. I will then complement this consideration with a few comments on recent events. As Judge Zima pointed out, Article 48 makes it clear that if an obligation is either erga omnes partes or erga omnes, based on a treaty regime or on general international law, all states parties in the former and all states in the latter case are entitled to invoke the responsibility of the wrongdoing state. Let me add that this point has been reaffirmed in subsequent ILC work, most recently in the draft conclusions on peremptory norms of general international law, jus cogens, adopted in first reading by the Commission in 2019. Regarding state comments on obligations erga omnes in 2000, and that Zima already referred to this, two main concerns were expressed. The first concern was related to the potential of the invocation of responsibility by a state other than an injured state to encourage the proliferation of disputes, thus opening the floodgates of litigation. The other related to the disorder that could be created by collective countermeasures. The Commission's proposed provision on standing was supported by states as an important tool to implement state responsibility, but some concern was expressed regarding its wider implications. In particular, it was said that a general provision enabling more than one state to invoke the responsibility of another in respect of a wrongful act could give rise to abuse. Various states might formulate inconsistent or even contradictory requests, and compliance with one such request and not others might further complicate the situation. As far as collective countermeasures were concerned, Commission's proposal received some support. At the same time, the risk of serious abuse was cited and strong opposition was expressed to the possibility that an interested state, even if not injured itself, might take countermeasures without even consulting the affected states. It was also suggested that collective countermeasures were inconsistent with the principle of proportionality and could lead to the undesirable consequence that countermeasures might greatly outweigh the extent of the injury. Finally, some states were reluctant to accept the idea that the right to react could be delegated to a group of countries acting outside any institutional framework. It was emphasized that the draft articles must not be allowed to create overlapping legal regimes that could weaken the UN as a whole or marginalize the Security Council. Most criticism were thus addressed to the possibility of collective countermeasures, as we already heard, the issue of standing being far less controversial. And this was also reflected in the final articles. In general, there's an inherent balance in the ILC output as a result of the Commission's internal debates and in particular the regular feedback received from states. As far as Article 48 is concerned, this is obvious from the clear distinction made between an injured state on the one hand and other states that have a legal interest in the performance of the relevant erga omnes obligation on the other. While any of these states can institute proceedings, provided of course that there's a jurisdictional link, only the specifically affected state or injured state has the right to reparations. Furthermore, the capacity to institute judicial proceedings is distinct from and does not entail any right to collective or third-party countermeasures. As you just heard, the Commission originally linked collective countermeasures to erga omnes obligations, but decided in light of the comments received from states, to replace it with a simple savings clause referring to the right to take lawful measures to ensure the cessation of the breach. It's therefore interesting to note that both arguments continue to be made and surfaced also in the Gambia-Myanmar proceedings. I quote a senior member of the delegation of Myanmar. If a state not specially affected can seek enforcement of Erga Omnes partes obligations by bringing a claim in this court, there would be no reason why it could not seek enforcement of those obligations by taking countermeasures. And allowing a pure actio popularis would, in his view, open potential floodgates. It seems, nevertheless, that the fear of proliferation of disputes and opening of the floodgates of litigation has been greatly exaggerated. States do not generally seem willing to make use of this opportunity without careful consideration. As far as collective countermeasures are concerned, the practice remains inconsistent and has been further blurred by references to collective countermeasures in bilateral contexts. At the same time, it is not difficult to find examples of states reacting to violations of essential international norms by taking lawful measures, as envisaged in Article 54. These include the exercise of universal criminal jurisdiction and reliance on specific treaty provisions. A recent example of the former, Germany, has taken a lead in investigating and prosecuting war crimes and crimes against humanity committed during the Syrian conflict. In some cases, the accused has been of German origin, but many have relied on universal jurisdiction. As for the background, there's reason to recall that we are now in the 9th year of the Syrian civil war, and we have seen the veto right being used in the UN Security Council no less than 16 times, inter alia, to prevent the referral of the situation to the International Criminal Court. Another example is about the Netherlands bringing the Russian Federation before the European Court of Human Rights for its role in the downing of the Malaysia airline flight MH17 in July 2014. While the Netherlands obviously can be regarded as an injured state in this case, it is noteworthy that by submitting the interstate application, the Dutch government stated that it stands by all 298 victims of 17 different nationalities and their families. The MH17 case, too, was brought to the Security Council, and a draft resolution was presented regarding the establishment of a special international criminal tribunal for the case in 2015. The Security Council failed to adopt a resolution following the use of the veto. Finally, reference can be made to several states suspending this autumn the application of an extradition treaty with Hong Kong out of concern for the human rights of the persons who might be re-extradited from Hong Kong to China. These recent examples of selfless interventions, and there are many more, show that lawful measures can play a useful role when institutional solutions are not available in contributing to the enforcement of communitarian obligations. The Gambia-Myanmar case is exceptional and unprecedented, but it stems from the same concern as the three examples just given, about the need for more accountability for state action that disregards basic humanitarian norms. Thank you so much.
Thank you so much, Ambassador, for offering us that very, very intriguing perspective. I think now we'd like to hear from Mr. Reichler, who will tell us about his role in procuring the court's really landmark order that the ambassador just referred to in Gambia versus Myanmar, and the significance of that decision in the progression towards community values and international law.
Well, thank you very much, Nawi. And I'm very grateful for the opportunity to have heard Judge Sima and Ambassador Lehto with their really outstanding and informative presentations. I know I learned a lot just by listening. I speak to you and to the group today as a practitioner of public international law. My practice for the last 3 or 4 decades has been to represent sovereign states in litigation before the International Court of Justice and other international courts and tribunals. And I am the lead counsel for the Gambia in its case against Myanmar under the Genocide Convention. I've also had the honor to appear as counsel in the most recent case involving Erga Omnes obligations before the Gambia case, which was the advisory proceedings on the legal status of the Chagos Archipelago, in which I served as counsel to Mauritius. Now, in that case, the court found that the United Kingdom's unlawful detachment of the Chagos Archipelago from Mauritius, the Chagos Archipelago, the court found, is and always has been an integral part of Mauritius' territory. The court found that that violation, that was a violation of the right of people to self-determination, because the detachment during the colonial period was not with the approval of the Mauritian people. They did not have an opportunity to freely express their will. And therefore, this was a violation of the right of self-determination. And that is what gave that case its Erga Omnes character. Now, the Gambia case, of course, involves violation of the Genocide Convention. And you asked me to address why Gambia? That is, why is Gambia the applicant state in these proceedings? And the answer is that when the United Nations agencies, including the expert fact-finding mission that had been commissioned by the Human Rights Council, published its first comprehensive report on the crimes that Myanmar was committing against the Rohingya Muslim population, and called it genocide. This, of course, was quite alarming to the member states, the 57 member states of the Organization for Islamic Cooperation. They formed an ad hoc ministerial level committee of 8 states at the foreign minister level. The Gambia is one of those states. It was represented by its Attorney General, Mr. Abubakar Tambadou, who had been, before returning to Gambia as Attorney General, a prosecutor at the International Criminal Tribunal for Rwanda. And when he visited the camps on the Bangladesh border of the hundreds of thousands of refugees, Rohingya refugees who had fled the slaughter between 2016 and 2018 in Myanmar, he told the other ministers who were part of the delegation, OIC ministers, this has the stench of genocide. I know it from Rwanda. He became the chair of the ad hoc committee. The OIC decided to support a lawsuit in the ICJ against Myanmar under the Genocide Convention, and it was determined that the Gambia would be the applicant state. Now, there is only one applicant state, and that is the Gambia. But the Gambia's initiative was fully endorsed and maintains the endorsement of the full Organization for Islamic Cooperation. And of course, since then, dozens of other states have expressed their support for the Gambia's initiative. The Gambia has written to the court in its application and again in its oral pleadings on provisional measures in December 2019 that it has standing because the obligations under the Genocide Convention are Erga Omnes obligations, and it does not need to show a special injury or a special interest other than the fact that it has the right to bring these proceedings both as a party to the Genocide Convention, because the obligations under the convention are owed at the very least to all of the other parties to the convention. And of course, it was relying on the analogous case of Belgium versus Senegal, in which the court held by an overwhelming majority that Belgium had the right to sue Senegal under the Torture Convention, notwithstanding the fact that it did not have a special injury. In fact, the court did not even consider it necessary to consider whether Belgium had a special injury because of its ruling on the erga omnes nature of the obligation and the standing that Belgium had thereunder. Now, the ICJ has addressed this, at least in a prima facie way, in its order on provisional measures of the 23rd of January, 2020. As you know, the provisional measures order was issued unanimously by the court, 17-0, with even Myanmar's judge ad hoc voting in favor. The standard at the provisional measures phase, the bar at the provisional measures phase, is to show standing prima facie. So we cannot say that the court has resolved the standing issue, but it found that on a prima facie basis, Gambia's argument that it has standing because of the erga omnes character of the obligations under the Genocide Convention has been accepted, again, prima facie. Now, one of the issues that you asked me to discuss was the difference between the separate opinions of Judges Shui and Judge Donahue. Because this is an ongoing case and I am counsel before the court, discretion requires me to be, shall we say, very discreet in commenting on the judge's separate opinions in this ongoing case. I will say, and I think it's appropriate for me to say that in respect of Judge Shui, her separate opinion is consistent with the position she took in the Belgium-Senegal case on the standing of Belgium. But I would point out that she was one of only two judges, the other being the judge ad hoc appointed by Senegal to vote against standing for Belgium. Judge Donahue, who has a separate opinion in our case, in the Myanmar case, the Gambia case, let me call it by my client's name, the Gambia case, Judge Donahue was part of the overwhelming majority in Belgium-Senegal, and in her separate opinion in the Gambia case, she makes clear that she thinks the same reasoning that convinced the majority of the court in Belgium-Senegal is applicable to the Gambia's case under the Genocide Convention. And I think one of the points that she has made in both cases, and I won't do justice to her eloquence and elegance in setting out her legal views, but in my layman's interpretation, Judge Donahue has said, well, it really makes no sense not to consider these obligations erga omnes and then have a provision in the convention allowing jurisdiction in the court, because very, very, very rarely in the case of violation of the Torture Convention or violation of the Genocide Convention, is a member state, a state that's a party to that convention, going to have a special interest. And thus, enforcement of the obligations will suffer tragically. And by the very nature of these conventions, the obligations were intended to be erga omnes and to allow other states, at least those states parties to the treaty, to enforce the obligations. That, of course, is consistent with the Gambia's views, and indeed, as expressed by the Gambia in its written memorial of some 500 pages of text and 5,500 pages of written annexes, which was filed today in the International Court of Justice, 23rd of October, which was the due date. So we're very pleased to have completed that massive work and to have presented the memorial to the court today. Now, another issue that you asked me to address, and I'll be very quick to save time for follow-up questions and questions from the audience, is the issue of intervention. This is a very interesting question. It actually leads to a series of very interesting questions. We know, as a matter of fact, that Canada and the Netherlands have indicated their intention to intervene in the case of Gambia versus Myanmar. We are presuming that the intervention would be under Article 36, which allows states that are parties to the convention that is being construed in this case, the Genocide Convention, to intervene as a matter of right. Now, whether they will address the issue of erga omnes obligations, we don't know, or whether they will address other aspects of the convention remains to be seen. But clearly Canada and the Netherlands have decided that they have interests in the way the Genocide Convention is construed by the court in this case, and they will be intervening in order so that they may be heard on construction of whichever provisions of the convention they are concerned about. There's another interesting question that's raised, and I think I'm going to do no more than raise it. I would defer to Judge Sima and Ambassador Lehto because their opinions on this will be weightier than mine. But and that is the question of a potential intervention under Article 62. This, of course, is not limited to parties to the convention and is not intervention as of right. But an interesting question would be raised if a state that is not a party to the Genocide Convention were to seek to intervene as a party under Article 62, claiming that it has a legal interest, perhaps as a member of the international community, although not necessarily a party to the Genocide Convention, a legal interest in the proceedings. Of course, that kind of intervention would not be an intervention of right, but would be subject to the court's discretion. And it would raise for the court the question of whether a state that is not a party to the Genocide Convention may still have a sufficient legal interest in the convention and the way it is interpreted and applied to be allowed to intervene in the proceedings. We would force the court to, or not we, but whoever attempted such an intervention would force the court to dig down even deeper in addressing the nature of erga omnes obligations. So with that, I will conclude my opening remarks. And thank you for inviting me. It's a great, great privilege. Indeed, it's an honor to be on the same panel as Judge Sima and Ambassador Lehto, and happy to respond to any questions that you or members of the audience might have for me.
Thank you so much, Mr. Reichler, and to all of the panelists for those truly insightful and incredibly informative remarks. We had during that, there were follow-up questions that I was hoping to ask that I deferred in the interest of time. And hopefully we can touch on some of them in this like interactive perspective-looking discussion. And perhaps the best way to start that is by allowing Ambassador Lehto and Judge Sima to weigh in on Mr. Reichler's inquiry about the potential for Article 62 intervention with respect to a non-party to the Genocide Convention and the challenges that would be faced, including jurisdictional challenges. And I leave it to either of you to jump in, please. Perhaps you'd like to go first, Judge Sima.
Well, I of course, ladies first, but okay. The question whether a state which is not a party to the Genocide Convention could more or less join or bring a case of its own is, of course, a very interesting question and extremely controversial, I might think. While Paul spoke, I thought of the report of the Institut de Droit International, the Institute of International Law, a report that was adopted by the Institute in 2005 at its Krakow session. The report was based on work of Professor Giorgio Gaia, who is currently a judge at the ICJ, actually my successor. And in that report, you find an article. There is no distinction made in many regards between obligations erga omnes, full stop, and obligations erga omnes partes. And what the report says is that if there is a, of course, in all these cases, this hasn't been mentioned up till now, for a case to be accepted by the court, there has to be a dispute between the states concerned. And there have been cases where, for whatever reasons, the court took the view that there was no real dispute and therefore bye-bye to the case. And we're all aware of these cases, like the nuclear arms case brought by Pacific Island against the all nuclear weapon states, etc. But so if there is a dispute, and the Gambia Myanmar case would be a good example of how to develop a dispute. How far do you have to go? What precisely do you have to do for the ICJ to accept that you are actually in a dispute? If that is given, and there is a legal, let's say, there is a jurisdictional lien, let's say, between the two countries, then also a non-state party to a treaty could bring a case before the ICJ. But of course, the problem with the Genocide Convention is that this is the basis of jurisdiction. So there would have to be another basis of jurisdiction, like common membership in the optional clause system. So that might be attempts at answering the question.
Thank you very much. That's very informative. So maybe we can kind of proceed to the more perspective-looking discussion. And I think a lot of the audience will be interested to hear maybe some of the implications of the court's order in Gambia versus Myanmar. So it clearly represents another evolution towards the enforcement of community values before the ICJ. But what are some of the practical implications? You know, what kind of doctrinal evolutions can we anticipate next? And you know, how can we, what kind of implications could it have for dispute settlement, for example, before other international courts and tribunals? And perhaps we can hear from Mr. Reichler first. I think you're on mute. You're on mute, Paul.
I'd prefer to hear from my colleagues on the panel before addressing that, if that's all right with you, Nawi.
Yeah, of course. Anybody's welcome to jump in. I know one thing that we were hoping to hear about was some of the diplomatic implications of the court's, recognition of this very broad standing for Erga Omnes obligations, and how it could implicate efforts to mobilize the international community for humanitarian intervention or countermeasures. And so I think that's a related point that perhaps the ambassador would like to weigh in on.
Thank you very much, Nawi. Let me say that the recognition of Gambia's standing clearly is important as a missing piece that is consistent with the earlier jurisprudence of the court, but really provides something new. In concrete terms, I'm sure that a number of states are considering the opportunity of intervening, and that might make a difference. I know that the decision by Gambia to take a lead in this case was really appreciated by many of those who have defended human rights. You were referring to countermeasures. As I said, or tried to say in my presentations, I believe there are many opportunities provided in the way of lawful measures. I made I presented the examples of universal jurisdiction, universal criminal jurisdiction, and there's several treaty regimes which have specific provisions that can be applied to defend communitarian or Erga Omnes norms. But as you know, the situation is quite difficult, and many of these issues that were taken for granted 20 years ago have since then become controversial.
If I may, Nawi, I'm glad I did defer to Ambassador Lehto for her words of wisdom. But I think it might also be useful in response to your question. And I will admit that I peeked at some of the questions that have been asked by the attendees. And I think I can relate the two. It's interesting to compare the Gambia case against Myanmar under the Genocide Convention with the court's advisory opinion in the Chagos Archipelago case, particularly because, as I see from the questions of some of the attendees, question is whether Erga Omnes obligations can arise only from conventions, that is, they have their source in conventions, or whether they can arise from general international law. And I think the Chagos Archipelago, of course, the Gambia case against Myanmar is a case where the obligations arise under the convention. And we argue that those are Erga Omnes obligations. But in the Chagos Archipelago case, the Erga Omnes obligations did not arise, found by the court, did not arise under a convention, but under the rules of general international law. The court found that the United Kingdom was under a legal obligation to terminate its unlawful administration of the Chagos Archipelago as rapidly as possible. But in the part that is most relevant to this discussion, it also determined that the United Kingdom and all member states of the United Nations have an Erga Omnes obligation to cooperate in the completion of the decolonization of Mauritius because of their interest in the right of self-determination of peoples. So there is an Erga Omnes obligation that arises from principles of general international law, of course, derived from the Charter, from 1960 Declaration on Colonial Peoples, that was felt to represent opinio juris at the time. But these are obligations under general international law that are considered erga omnes and recognized as such by the court in its advisory opinion in the Chagos Archipelago case.
I might add that similar thought can also be found in the opinion of the court rendered in 2004 in the Wall case.
Yes.
On Palestinian territory, where some of the rules that the court found had been breached by Israel were not based on treaties or only partially based on treaties like the international covenants, but also on general international law. And the court also spoke of Erga Omnes rights and obligations there. So I think that my wish would be that we get more cases like yours, Paul, if I may call you the owner of the case. Because I find it's just a necessary maturing of international law to the conditions and necessities of today. We are not going to get far with traditional thinking in a number. It's not just human rights. It's also environmental protection and other matters.
Well,
The problem I see, if I may just have 30 seconds, the problem I see is when you look at international law, at the development of obligations erga omnes, what we're talking about, you see there is international law is getting more and more what I would call public international law features, public law features, and a certain degree of what especially the Germans have called a constitutionalization of international law. And this is a good thing. On the other hand, what we see is there is a process like that in states. This maturing and constitutionalization was driven forward or accompanied by a general, let's say, institution of a general community power that we do not have in international law. We have the Security Council, but I don't want to go into that any further. It is not a central executive of the international community. And so the international community, this is a dangerous thing, leaves the implementation of community interests to its single members. And then we get to collective countermeasures and all the dangers. So I think the more this individual intentions end up in The Hague at the ICJ, the better and the safer.
Judge Zimmer, I agree with you fully from the heart as well as the head. But the one thing I do have to, with all due respect, correct. I don't want to be referred to as the owner of the case. I am very proud to be counsel in the case, but I wouldn't want that to go unremarked and to create the wrong impression. This is very much the Gambia's case. As I said, it emerged out of discussions that the Gambia had with its fellow members of the Organization for Islamic Cooperation. The decision was made to bring the case, and then they sought counsel. So I wouldn't want anyone to have the erroneous impression that there were counsel out there encouraging potential clients to bring a case. That is not the case. The decision was made, and then they found me.
No, but Paul, don't be too modest. Wherever a very interesting case pops up in The Hague, lands in The Hague, there's a very high probability that you are going to be the team leader there.
That's very kind of you.
So perhaps we have a moment for one more follow-up, which I think was just alluded to in the previous discussion. Most of the cases before the ICJ concern treaty breaches. So, we can have obligations erga omnes partes arising out of the treaty. But obviously we also have erga omnes obligations in general international law. So when we know, from, for example, ICJ jurisprudence that an obligation is erga omnes in general international law, how does that affect the determination of whether a related treaty obligation is erga omnes partes?
Madam Ambassador, I'm sure you're pining to go into that as I am. No, not really. This, of course, is a very difficult question. My hunch is that today, even though in the Mauritius case that Paul mentioned, he said that this was based on general international law, not on treaties. But I would say in almost all the domains which were mentioned in Barcelona Traction, we now have treaties in place, or at least treaties in place which cover at least a part of the problem. For instance, self-determination. Of course, it is in a way grounded in the common Article 1 of the international covenants, and therefore there is a treaty basis there, which of course doesn't yield much because it's just the general formula that you find there. In the rest, you have to figure out by the means of, let's say, how to identify and customary international law. I would just say the treaty, the Erga Omnes partes cases will be the easy cases. Once the ICJ takes up a case where the Erga Omnes nature is derived from, let's say, something like general principles or soft law, some soft law kind of growing into something a little harder, etc., then this will be very interesting, in a way, in the Chinese sense of the word interesting.
I would simply say, from a standpoint of a practitioner, we have to be very careful when we are preparing an application on behalf of a state to be mindful of the difference between standing and jurisdiction. And they're two different elements. And before the court, since jurisdiction is based on consent, there has to be some instrument through which consent is given. And I think that supports what Judge Zima is saying, why most of these cases arise under under conventions that have clauses in them providing for ICJ jurisdiction. That is where the consent is found. And of course, the Chagos Archipelago case is different because it was an advisory proceeding, and therefore a consent per se was not required, but it was a matter of the ICJ exercising its discretion to answer the questions that were put to it by the General Assembly. So I think as we seek to advance the community of interests, advance public international law, advance the rule of law at the international level, we attempt to that end to expand reasonably, not without limit, the concept of erga omnes obligations. We still have to be mindful of the need to establish jurisdiction, and jurisdiction and standing are different. So that will operate as a limit on the ability of those who seek to move the law forward in a progressive way to do so.
Indeed, the Judge Greenwood's glass slipper problem emerges again. And thank you for that important clarification. While erga omnes obligations can't create jurisdiction, as you've helped demonstrate, sometimes they can create standing, and there are some really impressive opportunities that can come along with that. But those opportunities have to be pursued responsibly. Thank you all so much. I couldn't be more grateful, and I'm incredibly delighted to have been able to play a small role in this incredibly insightful discussion, which I'm sure that all of the viewers are equally grateful for. A special thanks to Ukabiala and the ILW 2020 sponsors, each of our incredibly esteemed panelists, and most of all to everybody tuning in. That's our time. Everybody take care, stay safe. Bye.
Thank you.
Bye-bye. Thank you.